So the overall theme of this project and series of lectures is the right to research and international copyright. That's kind of the argument of next week, is that there are human rights obligations that impose duties upon states to construct copyright frameworks to include at least a minimum standard of privileges for research uses. We will talk about obligations to have those kind of exceptions within copyright frameworks next week. And this paper really starts analyzing where those exceptions exist. And in particular, are they adequate? So this paper asks, are exceptions within copyright adequate for modern research activities? And in particular, it uses the instance of text and data mining research, the phenomenon, if you will, of text and data mining research as that test. So are research exceptions in copyright laws around the world adequate in some measure to enable text and data mining research? Now, close readers, you will notice we're not actually answering the legal question of, is text and data mining allowed around the world? Because we're only looking at the faces of statutes. So we're looking at what the terms are within copyright statutes themselves, and then asking, could one interpret what we'd refer to as the openness within those copyright statutes? Could you interpret it to permit, for instance, text and data mining research? Is the statutory language open enough to be able to extend to that activity? But again, that's different than the legal conclusion, because just because your statute is open enough to potentially be interpreted that way doesn't mean it is interpreted that way. So in some countries, Argentina is one, for instance, there's a statutory mandate to interpret all exceptions very, very narrowly. And so it's possible that courts around the world would not take advantage of the openness or flexibility within their exceptions in any particular case. So what we did not look into is case law or regulations or even scholarly interpretations within each country. It's just too deep. So the methodology we used was to analyze just the statutory language that exists in copyright statutes and ignored, even where we knew about it, any information as to the actual interpretation of those laws over time. So the key footnote is, this is not legal advice. This is an empirical study. So one of the themes of this lecture series is on the globalization of law in general and copyright law in particular. How is it that all of our copyright laws look in some way extremely similar? And a key part of that story is international copyright treaties. The oldest of those, of at least the multilateral treaties, is the Berne Convention on the Protection of Literary and Artistic Works, that the first version was in 1886. Now, it's been amended a whole series of times, but in that original version in 1886, there was only one provision which mentions exceptions. And that provision was in Article 8 of the Berne Convention. As regards the right to include excerpts from literary artistic works for use in publications for teaching or scientific purposes, or chrestomathies, I haven't practiced saying that one, the effect of the legislation of the countries of the Union and of special arrangements existing or to be concluded between them is not affected by this convention. If you're cut and pasting from the Berne Convention, then the only exception you may have in your copyright law is one that allows just excerpts, not reproductions. Doesn't say general reproductions. Doesn't say you can use a whole work. It only says you can use an excerpt of a work. It can only be in publications. It's excerpts of other people's work in publications, and the publications themselves, the use for which it authorizes that publication has to be for teaching and scientific purposes. So it's not for entertainment purposes or other purposes. And it doesn't say you have to have them. It just says that that legislation's not changed. Nothing in the Berne Convention alters that, right? So why is Berne so restrictive on this limitation and exception? Why doesn't it mention the reproductions that researchers need in the course of research? And I don't have a clear answer here, but one other reason that does exist within the Berne Convention itself is that the Berne Convention in 1886 did not mandate that you protect reproductions. So it didn't need an exception for reproductions because the treaty itself did not require that your copyright law have reproductions. It only covered certain kinds of translations and publications. So the only kind of exception it needed to have was an exception for those publications and translations that the treaty itself protected. But you find by the late 1960, 1967 version, Berne Convention adds a reproduction right, requires all copyright laws to have a right of exclusive reproduction. It authorizes in Berne Article 9.2 what we refer to as an open exception. It shall be a matter of the legislation in the countries of the Union. So it's up for the legislation of each member to decide to permit the reproduction of just literary artistic works. No, now it says all works, reproduction of works. And then this is what we call the three-step test, right? Certain special cases, provided that the reproduction does not conflict with normal exploitation of the work and does not unreasonably prejudice the legitimate interests of the author. So any purpose, you can have an exception for any purpose as long as this flexible balancing test protecting the interests of the author is met. So it moves from a very specific science and education exception to an open general exception for any purpose. So you can think of that old Article 8 of the 1886 convention as being essentially a quotation exception, right? It's the inclusion of excerpts in other publications. Then that idea of quotation moves into Article 10.1 and becomes mandatory. So in the original Berne Convention, everybody could have an exception just for the use of excerpts in scientific publications, very narrow. And then it shifts to everybody must have a quotation. And then again, it's an open quotation right. It's quotation for any purpose as long as a balancing provision is met. So that's the current state of the international law. The international treaty structure allows a high degree of variation between countries. And so that's kind of the setup of our report. That's why we tell that story in the background, because then the empirical question becomes, well, what is that variation? So text and data mining research is the frame that we've been using and that we're using in the paper. So text and data mining research is when you take a huge amount of material, could be text, could be data sets, could be audiovisual material, could be sounds, could be images. You take all of these materials, depending on what your research project is, and you copy them, right? You copy them into your own drive or wherever you're keeping them, and into what we call a corpus is what it's usually called in this field. So you create a corpus. That corpus could have millions of materials, depending on what you're trying to do. Right? Essentially, internet search is a text and data mining project. You know, what does Google do to provide you with search? You're actually not searching the internet, you're searching a copy of the internet. So Google is constantly copying the entire internet onto its servers. And then when you type in a search, you're actually searching that copy. So sometimes you can like pick up a URL and you go to it and it doesn't exist anymore. That's because something may have changed in between the time the copy was made and the actual internet. So in order to do something like internet search, you actually have to do text and data mining on the entire internet, on every web page that's on the internet. And every web page is a work of expression and therefore is covered by most copyright laws around the world. Or what if you wanted to do a text and data mining project of every article that's ever been published around the world? Then you would need to make copies of all of those articles. You would have to find and make a copy of all of those articles that you want to search through and download them somewhere into a corpus. And then you create an algorithm, et cetera, to search over that corpus. So there are a ton of different examples, right? Text and data mining projects around the world. The discovery of COVID was actually done by an artificial intelligence company in Canada, and we'll look at their research exceptions at some point. And that company was a private company. It's a commercial entity, so it wasn't a non-for-profit researcher. They provide a service to a series of global companies around the world to try to predict where health problems are. And the way they do that is they digest into their corpus news articles, so those would be subject to copyright. Government announcements. In the US, government announcements are not subject to copyright, but in many countries around the world, they are. Health records, travel records, etc. And they digest all of these things into a big database and try to predict where those next health outcomes are going to be in order to advise huge multinational companies about which places to start avoiding. And in 2019, they started advising people to avoid places with large numbers of travelers from Wuhan, China. Now, they didn't know it was a coronavirus, but they did know that there was something going on, that there was a health outbreak traveling and globalizing before the WHO, before the US CDC, everything else. So it was a text and data mining company that actually discovered that. Text and data mining was used in the discovery of vaccines. So there were text and data miners who were digesting all the scientific articles they could find in the world and looking for correlations between coronavirus and possible vaccine candidates. And as you all know, this was some of the fastest vaccines to be developed ever. And part of that was because we have different research technologies available now. And then the third, slide at the bottom is the problem, right? If you don't have copyright permission to do this kind of stuff, then particular expressions that rely on text and data mining research can be removed from the public sphere. So in this case, it was a paper looking at vaccine hesitancy, trying to track where there are attitudes and what the attitudes are towards taking vaccines. And it was done in a series of countries, I believe, including India. And the regulators believed that there was no exception in their copyright law that allowed that harvesting of news information, and therefore gave a takedown order and removed that article from the public sphere. What do we need to create these kind of projects copyright-wise? So I mentioned that we have to make reproductions to create the corpus, right? If you're doing collaborative research, you have to be able to share that corpus between your collaborators, between multiple people in your research project. You may need to publish at least quotations that are the results of that research. You need the ability to use all different kinds of works, right? So there are text and data mining projects that involve audiovisual, for instance, certainly that involve academic articles. I've mentioned all web pages. Media monitoring groups look at broadcasts. So in order to enable the full scope of text and data mining research, whatever exception you have needs to apply to all works. And then potentially it could be done by any user, right? So certainly academics use this, but I mentioned the Blue Point is the name of the Canadian firm. They're a commercial entity. So commercial entities potentially need to intervene in this space too. To be fully open to text and data mining researchers, you would want a research exception that allows at least reproduction and sharing by any user of any work. And then for something like a research or a text and data mining purpose, something like that. The research question is, in copyright exceptions around the world, where do we find at least that much openness so that you could potentially apply the exception to TDM research? And again, I'll just add that qualification that we're not saying you can do it. You know, even if the exception is open enough to apply to TDM research, that doesn't necessarily mean you can do it, but it does mean that you potentially have a defense, right? That the exceptions environment in the law would potentially give researchers that defense, so they may be more willing to take on that risk. Now, I'll drop another footnote that exists in the paper, which is to say you might not need an exception to engage in some of these activities. There is scholarship saying, well, TDM activities, those shouldn't be considered to be included in the scope of copyright protection at all. To extract data out of a paper with a computer, that shouldn't be seen as a use that engages the scope of protection at all. You know, if a country adopts that line of reasoning, then you wouldn't need an exception for that research use in order to engage in text and data mining, because you could perceive that activity as being beyond the scope of copyright altogether. And that's another reason you can't assume that just because a certain country's exceptions environment is limited, it doesn't necessarily mean that you can't engage in a conduct, but it does mean that it's less clear. We've been using the term open as the most important term that we use in the research exception work. And by open, we mean that the language in the exception is sufficiently openly framed to apply to all works and users and uses. We refer to an exception as general if it lumps multiple kinds of purposes within one exception. A general exception applies to multiple purposes. Maybe not every purpose, but multiple purposes. So here's an example. This is a general exception because it applies for multiple different kinds of purposes or uses. Like you could have a separate, if you had a separate individual specific exception for each of these, then we would call that a specific, not a general exception, right? So if it just says fair dealing for the purpose of private study, then we would say, well, we'd say it's a specific exception for private study, right? But because it says fair dealing for the purpose of research and private study, education, parody, satire, so that's a whole bunch of different purposes in one. So we call that a general exception. So open is, does it apply to all or only some subset? General means, does it apply to multiple purposes? It's kind of like, is it a whole bunch of exceptions in one? And then flexible, almost every exception is flexible in some way, but flexible basically means, does the ultimate lawfulness of the use turn on some kind of a proportionality standard or balancing test? Like, is it fair? Is it fair to the author? Or are you using no more than is necessary for the purpose? That's flexible. As opposed to, and there are some of these that use very, very specific quantitative standards, like you can use 15%. You know, that would not be flexible. So that's the terminology. But the most important terminology that we'll really be using is that openness. But I'll refer to generality a little bit as well. This study looked at a basket of countries. About half were high-income countries and about half were middle-income developing countries. We didn't have any LDCs. And it looked at how open their exceptions were over time. So we actually went back to, I think, 1970 and then carried that information up to 2016 and looked at where both the statute changes And then in this study, we actually looked for case law changes too on how open their exceptions were over time. How much did they, when they amended their law or changed the interpretation of their law, did they expand it to include all works or all users or all purposes, etc. And you see there's a pretty clear trend line everywhere, which is that as laws are amended, they tend to have a general trend towards more openness. You see some ups and downs, right? But the trend is clear. But also there's a wide and increasing gap between wealthier countries and developing countries. So the middle income developing countries, if you look at it, I think the point at where they were in 2016 is about the point the rich countries were in 1984. You know, there's something like 30 years behind. And so that's part of the development dimension, you know, especially as we talk about how useful more open exceptions are to various kinds of activities, both commercial and non-commercial. This study did not look at all countries. This is a basket of countries. I think we had 24 countries or so. So we found a pretty clear trend in those 24 countries, but we didn't do what the research exception study does, which is to try to look at all countries. So as we shifted, we used some of the same criteria, especially that criteria of openness, but attempted to look at every country instead of a basket of countries. We also used a different methodology in that we have not, at least yet, made that time series data. So we did not look at changes over time. The research exceptions article is static. It's a snapshot of essentially where the world was in January 2021. So how did we analyze the data? So primarily we used a database called WIPO-LEX, which is a collection that tries to accumulate every copyright law and other intellectual property laws around the world. It's not fully up to date because it relies on countries to report. So there are problems with the database, but it is a pretty good place to find many laws to study. And so we ended up over time exploring that different openness factors with a six-point scale. And this is kind of ranked from most open is 1 to most restrictive is 6. And as I'll show you in a moment, and as you can see in the article, we have kind of 2 different maps of a 6-color, more in depth than a 3-color. In the 3-color, we lump all the kind of restrictive ones together. And so that's the 2, 3, 4, and 5. 1, and we label this green in our maps, are fully open research exceptions. So that means there's an exception either for everything. So if it's a general open exception, that's like fair use. It says you can make any use of any work by any user as long as that use is fair. That's essentially what the US law says. But we counted equally a specific exception for a research use as long as it was similarly fully open. So if it says you can make any research use of any work by any user, then we would code that equivalent to fair use. So those would both be green formulations in our map. 2, or blue, would be restrictions that only allow reproductions, but not other uses, and therefore may restrict, for instance, the sharing of materials between researchers. The light blue, or 3 on this list, is private reproduction. They add an additional restriction that the use itself must be private, which is also going to inhibit sharing between people, because usually private is an individual use. And then also implies non-commercial. So it's not going to be able to be used by organizations, companies, and often they say specifically it has to be a non-profit or non-commercial use. In purple, some of the laws only apply to institutions. In orange, the 5th element, some of the laws restrict the kinds of works that it can be applied to. And then finally, our most restrictive laws only allow essentially what that first Berne Convention referred to in 1886, which is just the uses of excerpts And some countries have laws that still only allow that minimum exception. So this is the map of the world in the 3-color. So basically everybody with a restriction of some kind is in yellow. The countries with open research exceptions are in green. Sometimes they could be fair use and dealing, but fair use and fair dealing, sometimes not. So many of those laws do come from the UK tradition, but not all of them. So you see open research exceptions in Germany or in Japan or in Indonesia, countries that don't derive their legal regime from the UK basis. But I think we'll spend more time, with this map, which gives you the more complexity. So just to remind you, the orange countries, and you see that becomes a big piece, are the countries that have a restriction on the kinds of works that can use. And another just note on methodology, the way we colored the countries here, because lots of countries have multiple restrictions, is we mapped a country according to the most onerous restriction according to that 6-point scale. So if you restricted yourself only to excerpts, but also only reproductions to excerpts, you would be red, not blue in this map. Light blue are the private use. You can only authorize a private use, so not an organizational, institutional, commercial use. Purple is the institutions only. Dark blue means you can use any work, you can reproduce any work for a research purpose by any user, but only reproduction. It doesn't apply to sharing, which often we call communication, which is necessary for like validation, collaboration, etc. We also map specific exceptions for text and data mining and mapped them according to the same scale. So now instead of general research exceptions, now you have a specific exception for one kind of research, which is text and data mining research. And this is the list of countries that, as of January 2021, had enacted a text and data mining research exception. And among those, you see only the top 4 actually give you all of the flexibility we would be looking for, applying to at least reproductions and communications by any user of any work. And in addition, this part of the paper maps some other restrictions that we sometimes find within text and data mining exceptions, such as some of them, if you have an N in the commercial column, that means commercial uses are not allowed. In the second column, lawful access, and a Y means that lawful access is required, so you can only use lawfully accessed works. And then finally, protection from contracts. If you have a yes there, that means that that contracts can't override that exception. Okay, so next we can get into just a few examples of each of the categories. So in this version of the paper, we gave you a green label if either your general research exception or a general open exception is fully open. So the United States, you see, is open to any use. So it just says a fair use of a copyrighted work. It includes research as one of the examples, but the key language there is such as. So it doesn't have to be for that list of purposes. So in the US, because it has such as before the list of purposes, you can use that work for any purpose. Singapore, and this is their older law, but used the word fair dealing, but applied to any purpose. So that both of those are open general exceptions. Or you see Germany has an open text and data mining exception. So it only applies to text and data mining, not all research, but it specifically allows both reproduction and making available to the public, applies to any work by any user. Blue, as I mentioned, is laws that only apply to the reproduction right, but not to the communication right. So for instance, the most recent European directive requires all countries to at least have a reproduction right, but doesn't require that they have a communication right. Or Switzerland, as example, only applies to the reproduction right. Light blue, as I mentioned, private use. So the exception itself requires that the use either be by an individual or says something like in Senegal, personal or private use of the word. Institutional rights, again, so the rights here, instead of being to an individual, are only to an institution. For instance, Ecuador is only libraries and archives. Panama, research institution. Cuba, library, documentation center, scientific institution, etc. Orange, exclusion of different kinds of works. So often, many laws follow that Peru example. They exclude 3 things. You're allowed to use articles, but you can't use whole works. And then often databases or sometimes computer programs are accepted. Hungary is my favorite one. It's kind of funny. So Hungary gives us any other mechanism, but if you want to handwrite it, you can copy the whole book. You can sit there in the library and word for word copy it with a pen. They're actually changing that one now. And I presented this to some Hungarian copyright officials, and they laughed along with us and said, we're doing it. We're taking care of that one. We've noticed it. That's essentially, the end, but, where do we go from here? So I began and end at the same place, which is, so this course is about the right to research and international copyright. And we'll explore kind of each of those dimensions. So this paper shows a little bit of the problem. If you're thinking about modern research and what you need to do text and data mining, if you recall back to that map, very few of the countries are green. And so very few of the countries of the world do you really have a decent argument, even if there's no directly applicable case law, that my statute is probably wide enough to allow me to do it. But that's a tiny piece of the world. As I mentioned, we'll talk next week about the human rights dimension. Is there a duty of states to actually protect research uses within copyright? And then finally, international copyright. A lot of the problems in this area start with the international treaty environment that requires high protections for research and doesn't require any exceptions. So how can we solve that? Well, maybe we can solve it within changes to the international treaty architecture itself. And so I think that's, kind of a general introduction to some of the themes that we'll be coming back to.